and introduce yourself to our church this morning.
I'm Larry Todd. I'm the Assistant Solicitor from the 9th Judicial Circuit. My boss is Ralph Williams.
Okay. And are you, just a little bit about yourself, are you from the South Carolina area?
No, actually, most of my life was in Ohio. I was 20 years in the Navy. I was a JAG in the Navy.
Okay.
And then when I got out from the Navy, when I retired from the Navy, my wife had a good job here. We loved Charleston, so we stayed in Charleston.
Okay. How long have you been here?
We've been here since '87. I've been an assistant solicitor since 1994.
Very good. Now, a little bit about your position right now.
Okay.
What do you do?
I work with Judge Gosnell in preliminary hearing court. Preliminary hearing court is where it's not really a trial situation. It's the government has to establish that there's probable cause to continue to prosecute a case. So that's where the police officers come in and testify in front of Judge Gosnell, and we establish that there was probable cause that the offense was committed and that this is the person that committed the offense.
Okay. Can you clarify for our church that you've never seen me in the courthouse before?
That's true. I have not seen you before.
That's good. Now, previous to this position, you did something else in the solicitor's office. Is that correct?
Yes. For about my first 5 or 6 years in the solicitor's office, I was the felony DUI vehicle manslaughter prosecutor. And I did that, and I actually quit the office and was going to be retired. And Ralph asked me to come back when he was elected and do the preliminary hearing court job, and it's been a wonderful relationship ever since.
Very good. And so in that position, you actually tried cases?
Yes, in General Sessions Court, in South Carolina's felony court.
Right. Okay. And now a little bit about when you're getting ready to try a case, I'm curious how much of your time is spent in the courtroom versus gathering evidence, preparing your case, things of that nature.
In the solicitor's office, we have detectives that are investigators that are assigned to us to assist us. And of course, they'll help us in locating witnesses and bringing them in. And then for the actual trials, 2 or 3 weeks ahead of time, we're sitting down, going over the testimony of the witnesses, comparing notes, and we do a lot of that. But in the typical day-to-day business, we're usually doing pleas, in the court doing pleas, administratively doing warrants and drafting up indictments and things like that.
Okay. And this morning, we're speaking specifically about eyewitness testimony. Right off the bat, how vital and important is eyewitness testimony when you have a case?
Well, under the law, that's called direct evidence, and it's very important. Under the law, we don't distinguish between direct evidence, circumstantial evidence. It's all up to the fact finder to give whatever weight they think is appropriate. But as a matter of everyday course, it is essential to what we do, and it is in almost every case, and it's almost all of our evidence.
Okay. When you have an eyewitness, are there certain things that you look at, characteristics, credibility with an eyewitness?
Yeah. We're looking at the demeanor of the witness, how that witness presents himself, the background of the witness, whether the witness is a good citizen or not a good citizen, how that witness came to us. Is the witness a person that we had to grant immunity to come and talk to us, or is it a concerned citizen that came out of the blue and volunteered themselves to speak the truth or not? So those are a couple of the things that we look at.
And again, I'll allude to this later on, but having multiple eyewitnesses.
Again, under the law, there's no distinction between one witness and 20 witnesses. The court actually gives an instruction to the jury that you may believe the one and not believe the 20. Right. But as a matter of practical concern, obviously the jury is going to place more emphasis, or if we have 6 witnesses who who are telling you a consistent story.
Right.
So that's, the more witnesses I have, the better the case is.
Right. Have you been involved or know of any cases where an eyewitness, we see like witness protection program or threats to a witness? Have you ever seen any of those circumstances?
Yes, that unfortunately happens all too often. It's normally not carried out, but there frequently are verbal threats.
Can you give us any examples of cases that you've had been involved with where eyewitness testimony was kind of the clincher?
And actually, I thought about this question because I knew this one was coming, and it's very difficult to pick out one case. It's virtually every case. Eyewitness testimony is crucial, whether it's 1-on-1 or 6 against 1. The most recent case, just within the last couple of days, is we had a murder where a citizen hears a shot, goes out the back door, and happens to see the person that we believe is the culprit climbing over a fence, getting on a bicycle and riding away. And this person came forward. It was from a bad neighborhood. This is a good citizen, came forward from a bad neighborhood when everybody else was not coming forward, and his eyewitness testimony has been crucial in the case.
In looking at the series we're doing, we have written testimony from different individuals in the Bible, 6 that actually had face-to-face dealings with Jesus. In your opinion, to have what I would almost say 6 written affidavits of witnesses of an individual, would you find that to be compelling evidence to consider?
Well, yes, I would find it compelling to consider, but let me give a couple provisos to it.
Right.
One, I deal almost completely in criminal court, where a person has the right to confront his accusers. So we don't get to work with written testimony, recorded testimony as much as in a civil court. But certainly we still get prior written statements, written testimony becomes very important because you can compare what a person said this time and said the next time.
Right.
You can look at the internal consistency of the statement, and you can compare from one person's view to another person's view. And of course, it's permanent because it's written, so we can study it.
Right. And also, I would imagine in looking at these testimonies, especially when I look at the Scripture, the motivation.
Absolutely.
Of the witnesses.
The motivation of the witness, the bias of the witness, all of that comes to play. It's actually a little bit better when you're looking at a person face to face and you can and see their reactions, their demeanor. But you can still look at the consistency and the trustworthiness of what they're saying. Of course, and really, as in reading the Bible and religion and being a jury member, it all becomes belief. Right. Do you believe that person or not?
Exactly. Well, listen, Larry, I certainly appreciate your time. It's been good to visit with you. I have just one name I need you to be on the lookout for. That name is Jack Belcher.
Okay. I'll be looking for it.